Hello. Thank you very much for sticking around to this late hour. In England we say it's the graveyard slot, so it's much appreciated. And also, Francisco, thank you very much for inviting me and for giving me a reason to...
The responsibility of this panel is Alexander, because last October in Moscow, Alexander was fantastic.
Well, thank you very much.
At the same subject.
And thank you for inviting me. It's always a pleasure to come to Portugal. Okay, so the inevitable self-promotion, sorry, that was introduction, I meant. Kilburn and Strode, we're a leading European IP boutique firm, do the full service of all IP rights, patents, designs, trademarks. We deal with contentious matters, and also deal support, where we deal with due diligence and freedom to operate analysis, all these things that we've just heard about in this very nice presentation. Our clients range from multinational corporates to SMEs and universities, and interestingly, a number of Portuguese startup companies. So we have 4 Portuguese startups who are actually our direct clients. They choose to come to us, and we're working with them to develop their IP strategy and secure their innovation. We've got a single office in London. We're 160 people total, and of which 65 are actually attorneys. So that gives you an idea of the beast. So this is me. I'm a partner of the firm. I'm a physicist by background. Then I worked in neuroscience before leaving science behind and becoming a lawyer. I'm a European and chartered patent attorney. And there's some things on here which my mother would brag about to the neighbors, and my father would probably clip me around the ear. As I said, we have a wide range of clients, and what qualifies me to speak here today is that I've been involved in IP due diligence and IP aspects, really, of deals of all sizes, starting with university spin-outs and helping them to get investment ready, but also working with multinational corporates in terms of vetting investment targets and checking out acquisitions for them and whether it's a good idea to proceed or not. So, the topic of my talk is due diligence. And now, what is due diligence really? I mean, it's not limited to IP really, and I think really what you can think about is you ask the right questions, you get the right information, and then you proceed with confidence, or you don't because you know it's not a good idea. So really, the point here is to reduce the risk of nasty surprises that will kill any return that you hope to get on your investment. And clearly that's interesting for investors, but it's also interesting for those who want to be invested in, because making yourself investment ready means making it easy for the investors to do their due diligence, because obviously you want to be an easy sell. And if you're wondering why there are ducks on here, there's a story about a duck and asking the right question, and you can ask me later, I will happily tell it to you. Okay, now due diligence, that makes sense. We don't want nasty surprises, but why should you care about IP? What you can see here is that over the last decades, the percentage of value in the big companies has moved away from the bricks and mortars and the things you can kick generally to intangible assets, which is everything else. Now that's not the same as IP. It's not all intangible assets are protectable by intellectual property, or intellectual property doesn't cover everything, but intellectual property is the vehicle to monetize and to protect most of intangible assets. So there's no claim here that, say, patents are these days 80% of the value of a company. Clearly that's not true. But between the various rights there are in the IP field, it's a significant part of making sure that you protect the value in the company. So this is where you guys have a horrible slide of lots of text. What are the types of IPs then, these things that can protect the value in your company? Now, I'm going to try to make this easy on you. So first, there are certain things that protect technology. So we all know about patents. There are things called designs, which are more about how things look, but generally in an industrial context. Copyright protects how you express things, protects the work you've put into something. And there are, of course, trade secrets, where you can keep something secret. Hello. Right. Then on the other hand, we've got rights that protect the brand, the reputation, the good name of your company or the company you're interested in. And there you have trademarks, domain names, which are not strictly speaking protecting your brand, but these days your web presence is so important that really it's become a very powerful right. And you've got unregistered rights around this, which in various countries are called different things. So in the UK, we like to talk about goodwill. In Germany, for example, it's unfair competition. But really what it means is that nobody should trade on your good reputation. So another way to slice it is to look at registered rights versus unregistered rights. We're going to talk about in a second. So registered rights are where you go to the patent office and you submit a piece of paper and it goes on a registered, and so there's notice to the public that you own this right. So a patent is one example of this that is examined and put on the register. Designs are another example, trademarks are an example. And the important thing about these registered rights are that they're actually true monopolies. So if you invent something and you patent it, you get a patent for it, somebody else might come up with it independently, but you've staked the ground, and that's it. Nobody else is allowed to come into the territory that you claimed out in your patent. Now, on the other hand, there are also things called that there are also intellectual property rights that are not registered, that simply exist. They come into being automatically. So, for example, a copyright. If you write a lovely song, you have copyright in that song. There's nothing you can do about it or have to do about it. It just exists. But on the other hand, there's a difference here because those rights, because there isn't this notice to the public, and they are not monopolies. They're anti-copying rights, if you like. So if I happen to write the same song that you do independently, which admittedly is quite unlikely, then that's fine. I haven't copied from you. But what I'm not allowed to do is to copy your work and all the sweat of your brow you put into writing that song. So those are unregistered rights. This gives you a bit of an overview of what intellectual property rights are. And then the question is, so we said due diligence, that's asking the right questions. So what kind of questions do you want to ask? And I've broken that down for you into 3 big headings. One of them is assets. So you want to investigate whether the assets that seem to be there, whether they're actually there and there's any value in those. That's one category. You've got agreements and obligations, which would be things like, for example, confidentiality agreements come under that. Do they stack up? Have you done the right thing? Do you have the right kind of agreements in relation to IP with your suppliers? That sort of thing. And then the last heading is third-party rights, the last issue of content law. It's all fine and well that you've protected your own IP, but that doesn't give you the right to do anything other than to stop others from doing what they would like to do. So because you have a patent for your product doesn't mean you can actually sell it. Somebody else might have a patent that covers it, and you have to deal with that. And so if you invest in a company that cannot operate because there's an infringement problem, obviously that's not a very good investment in most cases. So here's another sort of header that you want to think about, which is what rights do others have that can impede what I'm trying to do? And just when you might get worried, I'm not going to go through all of these, but I wanted to highlight a few of them. So when we talk about assets, so let's say, you want to invest in a company and they say, well, it's great, we've got 10 patents. What do they mean? Have they filed 10 patent applications? Have those things actually been granted? Because they may not necessarily be granted. The patent office may come up with a problem. Even if they have been granted, are they still in force? So we just mentioned annuities and renewal fees, so they may have allowed these patents to drop. And it's actually mind-boggling how often you come across this where people don't realize that actually, in good faith, they have just let it go and there was value once and now it's gone. So that's a big topic and one that's very easy to verify, yet a lot of times it's not done. Now, agreements and obligations, there are lots of them and you could talk about this forever, but probably the most important one is if your employees or the employees of your investment target invent something, then typically it will belong to the company. But if you have agreements with outside consultants that do design work for you, typically it won't. Typically, unless you do something else, the rights will remain with the consultant. And I mean, I've seen cases of a company saying, oh, we've got this great brand and we've just rebranded, it's fantastic. And when we looked into it, it turned out that actually they hadn't had any rights into it. The consultant gave them the right to use it for 5 years, and all other rights remained with the consultant, which obviously wasn't a very good deal. So it's crucial that, if there's any one angle of this sort of column that you want to think about, it's whether there are any issues with the ownership of the IP. That's crucial. And then finally, on third-party rights, of course, one big header is patent claims. Is there any risk of you infringing somebody else's patents? How do you go about investigating that? You can search to see whether your product might be covered by things out there, and then, well, you have to do some analysis and see what your risks are. Another one issue which is really relevant for anyone who invests or works in the ITC sector here and that doesn't really get enough attention as it is open source. So it's very, in the tech community, geek country, it's very easily done to say, oh, I've got this really good routine here on the internet, it's open source, it's a collaborative project, brilliant, I'll incorporate that into my product. Nearly all of these open source content come with a license attached that says if you use this, the thing you use it in immediately becomes open source as well, and you don't own the rights in it anymore, basically. You have to allow others to use it. And if you don't, then you're in breach of that license and you're infringing somebody else's copyright. So, and that's a real headache. That's a real headache for, particularly for big companies that have lots of developers, and they all go off and do their own thing. And policing that and making sure that, and first of all having a policy in it, but even policing it and making sure that, your code is clean and you don't have lots of open source code in it that jeopardizes the proprietary value of it. It's a bottomless pit, I would say. Right, so I hope that wasn't too painful up to here. In summary then, or as a sort of pre-summary, IP really is, there are threats and there are opportunities. You have assets, the target's IP, and there are threats, which is others' IP. What you can do, the others can too. And so you need to investigate these issues, but you need to have some sort of reality check as well on what you're doing. So the lawyers, like me, can get very excited and go away and do lots and lots of work into the nth detail, and it's going to cost the world, and there's no point. So it has to be relevant to the amount of money that's invested. It has to be relevant to what's at stake, and you have to find the right level of analysis so that it makes sense, basically. And then lastly, also I wanted to mention there are soft aspects of IP that sort of don't fall into the hard lawyerly stuff where you can do searches and it's never black and white, admittedly, but you can look at papers. But these are the things like the people and the culture. Is it innovative? Do people invent it? There's a value in that. It's very difficult to quantify. Does the company have the right processes in place? Is there a scheme in place to encourage people to invent, to maybe give them some money if they file a patent application and some money again if it grants, and then the person who filed most in a year gets an extra prize? Are these processes in place, processes to capture IP, to monitor that it's kept up to date? And is there a strategy? What is the IP strategy? Are you looking to corner your niche of the market? Are you trying to own the world? There are all kinds of strategies, and it's worthwhile thinking about these and thinking whether you think they're aligned with where the business should go. So then, this is the real summary. I would say to you that IP is not everything, clearly, although as an IP lawyer I might be tempted to say it is, but it is an important part of commercial reality, in particular nowadays. And it brings with it both threats and opportunities, threats that you need to be aware of and deal with, and opportunities that you will want to take. And with all of these, to make informed decisions, you need to know to ask the right questions. And often that means getting professional help to go really into the detail, but what really helps is to have a reality check on the lawyers you use and sort of have a high level of understanding to make sure that you're always in the driving seat. And that's it from me. Thank you.